Hey guys, Marc J. Victor here with the Attorneys for Freedom Law Firm. Today we're going to talk about a motion to remand. What the heck is a motion to remand? Sometimes it's referred to as in Arizona, as a 12.9, Rule 12.9 motion to remand. That's because that's where this issue is found in our Criminal Rules of Procedure, Rule 12.9. So what's a motion to remand? Well, what's happened, if we're talking about a motion to remand, is the case has gone to the grand jury. And the grand jury has considered the case and they have returned something called an indictment. The indictment is the charging document that a grand jury returns, the official document that charges a citizen or a non-citizen with a crime. Well, the grand jury is kind of a strange proceeding. It's strange in the sense that it's a secret proceeding. The defendant doesn't get notice of it. The defendant doesn't get to go. The defense attorney doesn't get notice, doesn't get to go. There's not even a judge. The people running this is the prosecutor's office. It's the prosecutor who presents the evidence, generally with a police officer or a detective, and the members of the grand jury and a court reporter, and that's it. So because of this state of affairs, the prosecutor is sort of charged with being what we call the minister of justice. Said another way, they got to present the case in a way that's fair to both sides. What does that mean? It means that they have to present what the applicable law is, not just the law that helps the state, but if there's, say, for example, self-defense statutes or other statutes that may help the defendant, they are required to present those as well to the members of the grand jury, right? The members of the grand jury are citizens. These aren't trained lawyers or judges. They're citizens, so we have to give them what the applicable law is in order for it to be a fair hearing. In addition to that, our courts have said that if the state is aware of evidence that we call clearly exculpatory, which means evidence that tends to show that the defendant is really not guilty of this crime. If it's clearly exculpatory, then the state is required to present it. So what happens in a motion to remand is the defense attorney will get the transcript that is preserved and created by the court reporter, right? The court reporter is in that grand jury proceeding in the grand jury room, taking everything down that's been said. We have a right to get that transcript. There are very short time limits here in terms of, if you look at 12.9, you'll see 25 days from arraignment or when the court reporter has filed that transcript, whichever is later. So you have 25 days to file the motion to remand. And what we're saying is, hey, we've reviewed the transcript, and what we're saying to the judge now is they didn't present it in a way that was fair. They either presented wrong statutes, or they didn't present the ones that helped the defense, or they had clearly exculpatory evidence that they didn't present and tell the grand jurors about, or there was something else that was biased about that presentation. I do want to note here that Arizona courts have said very clearly what you cannot do is challenge what the grand jury did by saying they just got it wrong. In other words, the evidence wasn't sufficient for them to return the indictment. If you go there, you lose. You don't get to challenge the grand jury on that basis. In essence, what you're saying is something about the presentation that the prosecutor presented to the grand jury was unfair, or said another way, it violated due process. And if the trial judge finds that that's the case, then they grant the motion to remand, which in essence throws out the charges and sends the whole thing back to the grand jury with instructions to the prosecutor this time to do it right, to either present the statutes you failed to present the clearly exculpatory evidence. Now, good lawyers who expect that there might be a grand jury presentation on the horizon will send a letter to the prosecutor and say, hey, Mr. or Miss Prosecutor, here's some clearly exculpatory evidence. Make sure you present it. You also can say to the prosecutor, and my client, the defendant, would like to testify in front of the grand jury. It's important to note that the defendant does not have a right to testify in front of the grand jury, but has a right to tell the prosecutor that he or she is available, and then the prosecutor communicates that to the grand jury, and then they get to decide whether or not they want to hear from the defendant or anybody else. They're in charge of determining whether there's probable cause to return an indictment on these particular charges. Okay, so lots of information on what a motion to remand is. You don't have to remember it all. If you have questions about that, feel free to contact me anytime. Again, my name is Mark J. Victor. I am with the Attorneys for Freedom Law Firm. You can find lots more information about us on our website. It's attorneysforfreedom.com. There you'll find lots of videos like this about many different aspects of the criminal justice system, along with articles and speeches and interviews and really everything you wanted to know and some things you didn't even want to know at our website. I hope this video was helpful.